Paragraph 4, and Attorney Hughes and I have already talked about would be you ordering us to engage in good faith settlement discussions. The only issue there, I think, well, since administrative procedure doesn't bring in the confidentiality provisions of 408, the order does so. And shall otherwise be confidential, non-discoverable, the usual drill on.
I think that makes good sense.
Yeah. Well, I haven't been heard on that.
Yeah, and if I can just finish, we disagree on the last clause, that what happens in settlement shall not be disclosed by the parties to non-parties. There's been a great deal of press on this. None of it originated from this department, very little of it, and that extraordinarily neutral from this department. And I think it would be detrimental to settlement discussions if settlement discussions wind up getting publicized.
All right.
So we agree with paragraph 4. When it gets to the word matter, we'd like to see a period put right there. So in other words, paragraph 4 would read, the parties are to engage in good faith discussions toward the resolution of this matter, period. This is a First Amendment case. We view this paragraph 4 as a gag order. So it's a gag order on top of the proposed gag order they've already given our client. So I think that counsel for the state, counsel for VSECU can work out how negotiations will be structured. I don't believe we need the hearing officer to issue at the outset what amounts to a gag order.
I guess I misunderstood. I thought that the basic issue was whether or not your settlement discussions were going to remain confidential.
And Rule 408 goes to liability and damages. We don't have liability and damages involved in this. That rule is designed for a very specific purpose, and this is not that purpose. I think counsel should be able to engage in conversations. We can talk first about what the ground rules will be. But we are very concerned that there is evidence that we have not had access to yet, that if it comes up in these negotiations, that somehow the state's going to argue it's off limits. And
oh, no, that's, you would not argue that, would you? I mean, certainly if this,
I'm sorry.
Yeah. I mean, if there's evidence that it turns out to be relevant, and you wouldn't use the settlement discussions to say that can't be admissible later on.
Absolutely not. Evidence is evidence.
Yeah.
That's straightforward.
Yeah.
What I am concerned with, and I have to tell you I've been burned on this, is stuff getting out that, well, the department said a week ago that they're willing to do this, and now in front of the hearing officer they suddenly say, that kind of thing just trashes any settlement discussion. You can't work.
You're both so experienced, it seemed like you know that that's not going to work. If you want operating in good faith, that's not going to get you to the
I agree.
Good faith resolution.
And frankly, Mr. Hearing Officer, I think we don't need to have you say that to us. So that's my objection to this paragraph. We can't even get to the what is fair game in a settlement discussion or what is off limits for further discussion outside the context of a settlement negotiation. I don't think we're going to resolve this.
That does sound. So your proposal is you agree among yourselves as to what will be disclosed.
Absolutely.
Okay. And then of course you have veto power.
Right. And I suppose if there's a disagreement as to how settlement discussions are to proceed, we may have to come back together.
I mean, at that point, we might as well have a hearing. I mean, if we can't get to the, if we can't agree to how we're going to.
If we can't agree to be confidential when talking, then we're in real trouble. I do would say there's no liability actually. What, $15,000 or something account on the credit union side, so there is that. So I think Rule 408 ought to be imported in here, and we can't do that privately. Only you can bring Rule 408 in.
put that? 408 is designed to keep from the jury discussions about where the deep pockets are, and if there's an admission of liability and the settlement discussions fall apart, the jury doesn't get to hear that I said, yes, my client, ran you over. That's what 408 is about. And, whether it applies in the hearing officer context, I would think any factual discussions that we have should be fair game for this hearing.
Well, then it doesn't sound like you're going to have a very productive negotiation if at least as far as my experience is, that you do have confidential. But if that's up to you, I suppose, Mr. Peterson. You can just say no, thank you.
As a lawyer with a lot of gray hair.
As a lawyer with no hair. Take your best shot.
I'm coming up behind you. The settlement is always preferable to litigation, in my view. The client is generally advised, well advised, to see if they can find a meeting ground. I cannot imagine that any lawyer could go into a settlement discussion knowing any discussion they have of the facts may then be presented, not the fact themselves, but their discussion of the facts is going to wind up being a subject for trial. That can't be done. You cannot talk to people like that.
No, I agree with that, and I think that if you each have these positions, it seems to me, if you insist on settlement negotiation being open.
Yeah, and I'm not saying that.
Okay.
What I'm saying is we don't need you to impose on us a paragraph that later can be parsed, especially this shall be non-discoverable, shall not be disclosed, yada, yada. We don't want to have a parsing later that is unfavorable to us when I think we're grown-ups and we can talk about how settlement discussions are going to be conducted.
Well, based on the respective positions, I have my doubts, but why not? Why not? Well, certainly makes sense to let you try it, and then if you want any help that I may be able to give, I'm happy to try. So at this point, I'll rule that we're not going to adopt anything after this in paragraph 4 after this matter. Period. And then if you're Mr. Peterson, you can just say this isn't working, and I think at that point, when you tell me it's not working, this probably should have a hearing, because I don't know what else is going to work.
Yeah.
That's probably accurate.
Yeah.